In the matter, my name is Ms. Anyela, holding record Mr. Kat for the accused person.
So the right to life is the most fundamental of all rights, and its loss, however, occasion calls upon the court to speak with sobriety, compassion, and respect for human dignity. In the same breath, a death by one's own hand is a profound tragedy. It calls not for moral judgment, but for careful legal reflection and humane understanding. In this case, the accused person is charged with aiding suicide, under section 225B of the Penal Code. The particulars being that on the 29th of July, 2022, at Kariobangi South in Buruburu, within Nairobi County, he cancelled Carolyne Njiri to kill herself by taking poison. The accused is also charged with neglect to prevent a felony, under section 392 of the Penal Code. The particulars being that on the 29th day of July 2022, at Kariobangi South in Buruburu, knowing that Carolyne Njiri designed to commit suicide, failed to use all reasonable cause to prevent the suicide. Lastly, the accused is charged with destroying evidence, under section 116, as read with 36 of the Penal Code. The particulars being that on diverse dates between the 1st of June 2023 in Kasarani Sub-County, knowing that his mobile phone with SIM card number 0729 480592, which was within his possession, might be required in evidence in judicial proceedings, he willfully removed it with intent to prevent it being used in evidence. The accused person denied all the counts, and in its endeavor to prove the charges, the prosecution called 7 witnesses. So allow me not to go through the summary of the evidence. Let me go straight to the issues for determination. The court has considered the evidence which was adduced by the prosecution witnesses and the submissions by the defense on a no case to answer. At the close of the prosecution case, the court is to make a ruling as to whether a prima facie case has been established against the accused person to warrant him to be placed on his defense. The term prima facie is defined as a case sufficient to establish a fact, raise a presumption unless disproved or rebutted. The standard of proof as to whether a prima facie case has been established was laid out in the case of Ramantul Bat as one which a reasonable tribunal, properly directing its mind to the law and evidence, will convict if no explanation is given by the defense. In the case of Republic versus Abdi Ibrahim, a prima facie case was defined as a case which on full consideration might be possibly thought sufficient to sustain a conviction. The court must therefore determine if the evidence on record is enough to sustain a conviction, should the accused person elect not to offer any defense. On the first count, the accused person is charged with aiding suicide, whereby it's alleged he cancelled the deceased to kill herself by taking poison. Under section 225B of the Penal Code, it criminalizes the offense of aiding suicide and provides that anyone who aids, abets, cancels, or procures another person to commit suicide is guilty of an offense. To prove this offense, the prosecution must demonstrate 1. That the deceased died by suicide, 2. That the accused person aided, abetted, cancelled, or procured the suicide, and 3. There must be a causal or intentional link between the accused person's conduct and the suicide. On the first element, on the first element of the offense, it's not in dispute that the deceased died by suicide. All the witnesses confirmed that the deceased had committed suicide by drinking an insecticide. PW6 told the court he was present when the postmortem was conducted by Dr. Ndegwa, who confirmed the cause of death was poisoning. On the second and third elements, the prosecution needed to establish that the accused person aided the deceased to commit suicide, and further, the accused person's conduct was intentional in aiding the suicide. In this case, apart from PW3 and PW7, none of the other prosecution witnesses were present at the scene when the deceased committed suicide. PW3 told the court that the accused person had called her downstairs and told her to give the deceased some milk. It was her evidence that when the deceased was unable to take the milk from her, the accused had given the milk to the deceased. On her part, PW7 confirmed that both her parents, that is the accused person and the deceased, were drunk at the time. It was also her evidence that she had the accused person tell PW3 to give the deceased some milk, and he also tried to give her some milk. According to PW7, When the accused person saw the deceased was foaming on the mouth, he asked her to call neighbors so they can take her to hospital. PW7 confirmed that the accused person had asked PW3 to assist him carry the deceased to the car of a neighbor whom she referred to as Pastor, and the accused person accompanied the neighbor and the deceased to hospital. PW7 told the court that the accused had sent her photographs of the insecticide. Sorry, this is PW4. PW1, told the court the accused person had sent her photographs of the insecticide which the deceased took together with photographs of the deceased taking poison and also a video recording the incident. PW4, who was a sister of the deceased, faulted the accused person for failing to take the deceased to hospital in time since the video recording was about 7 minutes. It should be noted, however, that although the video recording the video recording that was mentioned by the witnesses was not produced in court for the court to appreciate its contents, the court was therefore left with the oral evidence of the 7 witnesses. As earlier stated, only PW3 and PW7 were eyewitnesses to the offense, and the evidence of the family members of the deceased was purely hearsay. From the evidence of PW3 and PW7, several things stood out. Firstly, both the accused person and the deceased were drunk. Secondly, even in his drunk state, when the accused person realized the deceased had ingested poison, he thought of a way to counter the poison by giving the deceased milk. While the accused in his drunk state may not have appreciated the consequences of the deceased taking insecticide and the need to rush her to hospital immediately, after the accused realized the deceased was not improving, he got assistance from neighbors and they ferried her to hospital, where unfortunately she passed away while undergoing treatment. Looking at these circumstances, can the conduct of the accused person be said to be that of a person who was aiding suicide? I opine not. The court knows that PW4 faulted the accused person for taking 7 minutes to record the actions of the deceased to prove that she was dramatic instead of taking her to hospital. The court, however, begs to differ. In this case, the court was informed the accused person and the deceased were having some marital issues. In fact, according to PW4, the accused had moved out of their matrimonial bed but still used to go to the house of the deceased. PW3 and PW7 confirmed that when the accused and the deceased came home, they were arguing. I therefore believe the actions of the accused person in recording the acts of the deceased were motivated by self-preservation rather than malice, because without the recording, the accused may have been accused of killing the deceased. It is the said recording that actually saved the accused person from a would-be murder charge. Therefore, in respect to count number 1, there was no evidence that the accused person supplied any instrument used in the suicide, issued instructions, encouraged the deceased, used any threats, or in any way influenced the deceased to commit the act of suicide. On the second count, the accused is charged with neglect to prevent a felony. Under Section 392 of the Penal Code, it provides that every person who, knowing that a person designs to commit an offense and fails to use any reasonable means to prevent the commission of the offense, is guilty of a misdemeanor. In order to prove the offense, the prosecution must prove that firstly, the accused person was aware the deceased intended to commit suicide, and secondly, he failed to use all necessary means to stop it, was kept on top of the fridge. On her part, PW7 told the court the poison had been bought earlier to kill rats since they had a rat problem in the house. It's therefore evident that the poison which the deceased drank had not been bought on the fateful day. It was something which had been bought prior with a purpose, and the accused person may not have imagined the deceased would use it to end her life. Further from the evidence, the accused person and the deceased came home at the wee hours of the morning while drunk. They started arguing, and it's at this point the deceased decided to drink the poison. The accused therefore would not have known beforehand of the deceased person's intention to drink the poison. On the second limb, after realizing the deceased had taken poison, the accused tried to counter it by giving the deceased milk, and when this did not work, the accused rushed the deceased to hospital. The court therefore believes the accused person employed the necessary means to abort the suicide. On the last count, the accused is charged with destroying evidence, where it's alleged that on diverse dates between the 1st of June 2023 in Kasarani, knowing that his mobile phone, which had SIM card number 0729480592, which was within his possession and required in evidence, was required in evidence, but he removed it with the intent to prevent it from being used in evidence. The court notes that none of the 7 witnesses gave evidence in respect to this count. It should be noted the prosecution closed its case without calling the investigating officer, who would have shed light on the circumstances leading to this charge, as well as give the necessary evidence. The Court of Appeal in the case of Bukenya v. Republic held that the prosecution must make available all witnesses necessary to establish the truth, and where the evidence called is barely adequate, the court must infer that the evidence of the uncalled witnesses would have been an averse to the prosecution case. Having failed to call the investigating officer, the prosecution did not prove count number 3 to the required standards. Sometimes the law must pause not to assign blame but to acknowledge loss. In this case, while the court empathizes with the family of the deceased who are left without a daughter and the children of the deceased who lost a mother in such a tragic way, the accused person was also a victim since he also lost his wife and the mother of his children. In her evidence, PW7, who was the daughter of the deceased and the accused person, told the court, in part, and I will quote, "I know my dad very well. He was a loving father and husband." PW7 continued, "Dad struggled to carry mom and went to hospital with her. These are actions of a person who cares." From the evidence, it's clear the deceased died on the 29th of July 2022, but the accused was arrested on the 1st of June 2023, which was almost 1 year after the deceased had committed suicide. The arrest occurred after a video showing the deceased taking poison was allegedly leaked to Mpasho News, known for its sensational reporting, sparking a public outcry since the accused person was a well-known DJ. In her evidence, PW1 told the court the accused had sent to her the video of the deceased taking the poison immediately it happened. PW4 confirmed the family of the deceased were aware of the video from August 2022. However, at the time, the family of the deceased had no issues with the accused person, and he even actively participated in the funeral arrangements as confirmed by the witnesses. It would later appear the relationship between the accused person and his in-laws became strained since there was a tussle as to the custody of the children, and that was when the infamous video was mysteriously leaked. Looking at these timelines, it's possible, as inferred by the defense, that the video was leaked so as to negatively affect the accused person in the custody battle. However, as earlier stated, this video, which was a very important key of evidence, was never produced in court. In the case of Pierce Rapmena versus Republic, the Court of Appeal observed that it is gainsaid that the prosecution must prove a criminal charge beyond any reasonable doubt. As a corollary, any evidential gaps must be determined in favor of an accused person. Having considered the evidence in its totality, should the accused person elect not to offer any defense, the court cannot safely convict on any of the counts. I therefore find that a prima facie case has not been established against the accused person, and I proceed to acquit the accused person under Section 210 of the CPC on all the counts.
Your Honor, we are most obliged for the ruling that has been delivered by this court. We will be praying that the cash bill that was deposited by the depositor to be returned back to the firm of Okach and Partners Advocates. And we are very grateful for the said ruling.
Very well, so you can have the copy of the rulings applied to all the parties. In respect to the cash bill, you might need to file an affidavit by the cash bill depositor for it to be transferred to the firm.
That is in order, Your Honor.
Very well.
We undertake to do the same, and we are most obliged.